All right, folks, let's bring in our guest joining us this hour, national trial attorney Michael Jaafar. And, you know, Michael, one of the things that I think is a weakness in the Commonwealth's case, and I know you've been a fan of the Commonwealth's case, is in fact the motive. Right at the end of the day, that's what that testimony would go to, this idea of motive, that the two of them were fine. That even though they had arguments like everyone does in their relationship, it doesn't mean that she decided to hit him with a 6,000-pound vehicle.
Yeah, you know what? Here's the thing. I've been thinking about this whole motive thing. I've never believed that Karen Read had motive to kill or murder John O'Keefe, right? My personal opinion has always been that if she did this, it was an accident. It was an accident done in drunkenness. And we know that by law, if you're drunk and you're driving and you run into somebody, you take full responsibility in the eyes of the law. We've decided as a society that when you're drunk and you do something, even if it's unintentional, there are felonious complications. But to answer your question, I don't believe anyone would doubt that she did not have she had no intent to kill. She lived a blameless life up until this point. She was an accomplished woman, accomplished professor, accomplished finance person. Why on earth would she want to kill John O'Keefe? She had no motive. So I don't think, first of all, that's why the state, in this case, they weren't focused on her motive like in the first trial. They didn't focus on that at all. They focused on hard data, forensic data, because even the most well-meaning person can accidentally murder somebody when they get behind a wheel in a snowstorm and they're drunk. So I think that's where the state wants to let this thing be. They want to lay it there, and then the closing arguments, I don't believe Hank Brennan is going to say she had any intent to kill him, just that she was grossly reckless in her conduct.
All right, fair enough. All right, guys, stand by. All right, let's bring in national trial attorney Michael Jaafar. Mike, I'll start with you. It's interesting because all the most important things you need from Michael Proctor, we basically have. If you put him on the stand, and you referred to this earlier, prosecution was basically saying, they were baiting them, saying, you want to call him, go ahead and call him. Because all he's going to do on the stand is explain, yeah, I did those things, it was awful, but I did nothing to fix this case or do anything wrong in this case. That's what you don't want. So I flop back and forth whether he needs to be called because he's such an important part of this conspiracy, or are they okay with what they have? Where do you fall today?
There's so many good answers to that. First of all, the defense made a bunch of promises in their opening statements, and they basically told the jury that their theory is that Michael Proctor's a bad person. He was fired for his conduct in this case, so I don't see how they don't do it and not lose credibility. They made promises in the opening statements. The opening statements were replete with Michael Proctor this, Michael Proctor that. I think they lose a lot of credibility by not bringing him in. But also, as I'm reading these messages, I'm thinking to myself, this kind of helps the prosecution in some way, because the defense wants the jury to believe that there was a conspiracy and Michael Proctor was part of the conspiracy. Well, you just read how dumb and stupid this guy is. Are we expected to believe that this moron who could not keep his sick thoughts in his head and had to text about it, but was part of a conspiracy and covered it up and haven't said anything about it in 3.5 years, right? So I think this could be an asset for Hank Brennan if they bring him, which is why I think he was tempting them to bring him. He was baiting them to bring him. And I can't believe where we are, which is I don't think the defense is going to bring him, even after being tempted by the prosecution to bring him. So this is a bizarre world, but I'm having a lot of fun watching it.
Yeah, Mike, I want to ask you about Officer Devers. That's who Alexis was referring to. We heard her testimony yesterday. She was pretty feisty on cross-examination. Actually, she was on direct examination by the defense. And she was one that she initially said she saw I think it was the captain as well as Proctor in that area for a very long time. And then she goes and visits with the commissioner and then changes her story and says, oh, it couldn't have happened that way. The reason, and I will say this, and then I'll get your comment. She said because she actually signed out a lot earlier, so she couldn't have seen what she thought she saw. What do you make of that?
You know what? So here's the thing. This is an event that happened over 3 years ago, right? It's very understandable that people would not have the exact minutia of every single minute of the day that they were. At the time, they did not know that they were investigating a crime that would be the most famous retrial of the century, right? So is the jury expected to believe that 12 people in the house saw John O'Keefe come into the house, covered it up, haven't spoken in 3.5 years, and then the EMS agents, and then Michael Proctor and his team, and all of them are all part of it? It's the principle of logic called Occam's razor. Which story has the least amount of assumptions? That's usually the proper explanation. Is it that Karen Read as the forensic evidence showed, backed up into John O'Keefe, and he did not sway from where her car was. He was dead within 25 seconds after he stopped moving within 25 seconds after she backed up, or that Michael Proctor, Sergeant Mechanic, Sergeant Devers, all of these people went and took the taillight evidence, broke it. They knew that it would be important evidence. They ran to the scene, rushed ahead of the crime unit, the investigation unit, and planted under the snow, and then they took off the snow with the snowblower, saw the taillight evidence. It's just beyond imagination. It's just a farcical theory. So to me, I think that the juries in this case will make that inference only because of the fact that the context they've been given by Hank Brennan has been, look at the aperture data, look at the forensic data, look at the battery health, the battery temperature, and all of that. I think all of that within context will show them that the taillight evidence was broken by hitting John O'Keefe.
Michael Jaafar, what do you make of it? This is something that's got to be raising some eyebrows. Again, when we talk about some of the inconsistencies here that create a problem to get to a guilty verdict.
Michael, there's no inconsistencies with this taillight. This taillight was not broken it's very, very conceivable that it was broken on that tow truck or just shattered. It was already shattered. It was already cracked. There's many things that would have caused some of the taillight pieces to fracture from the car. We don't have to go all the way to Michael Proctor and his team broke it, took it to the scene. There's already shards at the scene, but they wanted to make sure there were more shards. It's just a completely farcical leap of logic for the defense. There's many things that could have caused more pieces to fall off that thing. It didn't have to be a police officer breaking it.
Yeah, but again, Michael, when you talk about the amount of pieces they found, they could basically reconstruct the taillight with the pieces they found at the scene. And if you look at the taillight there, sure, it could have broken on the way or whatever, but how did it end up at the scene such that the vast majority of those pieces ended up there? Again, just questions, Mike. We have no answers to this. But again, it just makes it difficult to get to that guilty verdict for the Commonwealth. All right.